Have you ever noticed how cops always lean on that split-second decision line after a shooting? Well, the Supreme Court just killed that excuse in a 9-0 ruling. And trust me, this one's going to ripple through every traffic stop, every body cam review, and every courtroom in America. Hello, everyone. This is Ted from Line 45. Today, I'm going to walk you through Barnes versus Felix, where the Supreme Court basically said cops can't just point to the last 2 seconds of chaos anymore. The whole encounter is fair game. Before we dive in, do me a solid. Smash that subscribe, tap the bell, hit all the dang buttons down there. You don't gotta, but it keeps this train rolling and lets me crank out more of this wild gun talk for y'all. All right, enough of that. Let's get back to it. 9-0 and no wiggle room. 9-0. That's how the Supreme Court came down in Barnes v. Felix. And when you see a ruling that is unanimous, you know it's meant to send a message. The court basically said, quit hitting pause at the last 2 seconds of a police encounter and calling it good. From now on, judges have to look at the whole thing. Every choice and every action that led up to the moment, shots were fired. Justice Elena Kagan wrote the opinion, and she was crystal clear. The Fourth Amendment's reasonableness standard isn't about a freeze frame. It's about the totality of the circumstances. Here's why that matters. In the lower courts, especially the Fifth Circuit, they had this moment of threat rule. They tossed out Barnes' family's case because they only focused on the instant Officer Roberto Felix was hanging on the side of the car. At that tiny snapshot in time, deadly force looked justified. But what about the minutes leading up? That's what the Supreme Court said can't be ignored anymore. Let's back up. This all started in Houston in 2016. Barnes was pulled over for over $3.50 in unpaid tolls on a rental car. Felix claimed he smelled marijuana, but no drugs were ever found. Barnes tried to drive off. Felix jumped onto the doorframe, and in those last moments, he fired 2 rounds that killed Barnes. The court didn't rule Felix guilty. What they did was wipe out that shield of looking only at the final seconds, and that's a huge shift in how every future police shooting case is going to be judged. From $3.50 tolls to a fatal stop. All right, let me walk you through what really went down that night in Houston back in 2016. Officer Roberto Felix gets a hit on a rental Corolla with a few unpaid tolls tied to it. We're talking just $3 and change. He pulls the car over, and behind the wheel is 25-year-old Ashton Barnes. Felix comes up to the window, asks for a license and insurance, and Barnes admits he doesn't have his license on him. Says the car is his girlfriend's rental. He's digging around inside, looking for paperwork, and Felix tells him to knock it off. Now here's where it starts to build. Felix says he smells marijuana. No drugs ever show up, but at that moment, he starts pressing Barnes harder. Barnes says he might have ID in the trunk, so he pops it open and even shuts off the car like he's cooperating. Up to this point, the stop's only a couple of minutes long. Then it turns fast. Felix tells Barnes to step out. Barnes cracks the door, but instead of getting out, he turns the ignition back on. Felix draws his gun, the car starts to roll, and he jumps onto the doorsill. From there, it's chaos. He yells not to move. He's hanging off the side, and within 2 seconds, he fires 2 rounds. Barnes is hit, the car stops, and Felix radios it in. From start to finish, the whole encounter lasted about 3 minutes, but those final seconds are what the lower courts locked onto. The 2-second shield cops loved. So here's the deal with how the lower courts handled this. They leaned on what's called the moment of threat rule, and it's exactly what it sounds like. Judges would hit pause at the exact instant an officer fired and only judge the force based on that frozen frame. That's what the Fifth Circuit did with Felix. They looked at those last 2 seconds, saw him hanging onto the side of a moving car, and said, yeah, deadly force makes sense there. Case dismissed. But think about what that leaves out. Barnes had already shut the car off, popped the trunk, and looked like he was cooperating. Felix made the choice to jump on the doorsill when the car started rolling, which obviously put him in more danger. By ignoring everything before the shots, that rule gave officers a free pass on the bad decisions that escalated the whole thing. Critics had been calling this out for years, saying it let cops walk into messy situations, crank up the danger, and then claim the law protected their split-second reaction. Not every court agreed with that approach. Other circuits said you've got to weigh the totality of the circumstances, which means the entire encounter counts. And that lines up with earlier Supreme Court cases like Graham versus Connor, where reasonableness was never meant to be a freeze-frame test. That split in the law is why Barnes versus Felix even made it to the Supreme Court, and it set the stage for Justice Kagan and the other justices to shut that loophole down. Kagan's hammer: context matters. When I read the Supreme Court's opinion in this case, it hit me how direct they were. Justice Elena Kagan, writing for all 9 justices, laid it out plainly. You can't just freeze the clock at the moment a shot goes off and call it fair. Courts have to look at the whole encounter, start to finish, when they judge if deadly force was reasonable. That's a big deal, because the Fifth Circuit had tossed the Barnes family's case by zooming in on those last 2 seconds when Officer Felix was hanging off the car. The Supreme Court said, nope, that's not how the Fourth Amendment works. I've dug through the cases they leaned on, and it makes sense. Graham v. Connor is the backbone. That's where objective reasonableness came from. Then you've got Tennessee versus Garner and County of Los Angeles v. Mendez, both reminding courts that context matters. They even cited Plumhoff v. Rickard to show how earlier actions can shape what counts as reasonable later. It's consistent, but it's also the court sending a clear message: no more blinders. Now this is the one that hits harder. The justices didn't rule that Felix himself broke the law. They didn't go that far. They just said the lower court used the wrong test and sent it back to be reviewed properly. And Justice Kavanaugh, joined by 3 others, added a point of his own. Cops don't lose the right to self-defense just because they made mistakes earlier. That's where the next round of battles is going to play out. No more hiding behind the freeze frame. Here's the part that really hit me when I dug into this case. The Supreme Court basically shut down the trick cops had been using for years. Under the old moment of threat rule, officers could ignore all the decisions they made that got them into a bad spot and just point to the split second where they felt scared. Courts would freeze the frame right there and say the shooting was justified. That shield is gone now. Think about Felix. He didn't just magically end up hanging off the side of a moving car. He chose to jump on that door sill. Under the old Fifth Circuit approach, none of that mattered. All the court cared about was that snapshot where Felix looked like he might be run over. With this ruling, the choice to climb into the car and the way he handled the stop beforehand all come into play. It doesn't automatically mean he's guilty, but now a jury can weigh whether his own actions created the danger. And that's a big shift. Judges and juries are no longer handcuffed to the final 2 seconds. They can look at the full encounter, whether Barnes was cooperating, what Felix said, if he escalated things too quickly, and whether he had other options. To me, that feels like accountability finally catching up with reality. Cops don't get to erase the lead-up anymore, and that changes how every police shooting case is going to be fought from here on out. What it means for citizens like you. So here's what this ruling really means for regular folks like us when we get pulled over. The court is saying judges can't just look at the final seconds anymore. They've got to weigh everything that happened leading up to it. That means the way you handle yourself during a stop and the way the officer handles you. All of it can come back later if things go sideways. I've made it a habit to keep things as clear and calm as possible. At night, I'll flip the dome light on. I keep my hands up on the wheel so there's no guesswork. When the officer walks up, I don't start fumbling around. If my license or insurance is in the glove box, I say where it is and ask before reaching. That way, it's on record that I wasn't making any sudden moves. If I'm carrying, I stick to whatever my state requires. Some states you've got to notify right away, others don't. Either way, I don't get cute with it. I'll tell the officer I'm legally armed and ask how they want me to proceed. I don't touch the gun. I don't even reach for my permit until I'm told. And honestly, recording's your friend. Dash cams, phone cams, courts have upheld your right to film as long as you're not interfering. With this new standard, that footage isn't just helpful. It could be the difference in how your case is judged. Training days are over. I look at what this ruling means going forward, and it's pretty clear cops and departments are going to have to adjust fast. Training isn't just about those last split seconds anymore. Now it's about how the whole stop is handled, from the very first contact. That means every command, every decision, and every move can get picked apart later in court. If an officer skips de-escalation or jumps into danger when they don't have to, that's going to show up in the record. Departments are going to rewrite their policies. Body cam footage, dash cams, and even radio calls will be weighed heavier than ever. Lawyers on both sides are going to build cases by laying out timelines instead of just showing a freeze frame of the final shots. And for officers, that means writing better reports and learning how to explain why they did what they did from the jump, not just at the end. The court didn't call Felix guilty, and they didn't say every bad tactic automatically makes force illegal. What they did was change the lens. Judges now have to look at the whole story. To me, that's how it should be. If an officer handles business right, the record will back them. If they escalate a simple stop into chaos, that's going to follow them too. This ruling makes sure of it.